Hello friends, good morning. My name is Chandrajit Mukherjee and I'm back with our continuation of our lesson which we have started yesterday on the salient features of the Indian Constitution. Today we're going to cover the second feature of the Indian Constitution, which is basically the various sources from where we have drawn some principles, some processes, some practices from different constitutions, constitutional documents around the world, and incorporated in our constitution. That makes our constitution a cosmopolitan constitution. Many people do criticize this for being copied from various sources, but trust me, the plagiarism concept does not apply here on the universal principles. Liberty is a principle, fraternity is a principle. You cannot have plagiarism, or you cannot have a copyright on that. All right, now going further with this topic, let me discuss with the various sources from where we have drawn various principles, starting off with the Government of India Act 1935. As I've mentioned yesterday, that almost 70 to 75% of our constitution is derived from the Government of India Act 1935, and that makes our constitution quite a bulky constitution. Main features that we have taken from the Government of India Act 1935 is the federal scheme, the federal structure, wherein there is a central and there is a vertical silos of power distribution. Responsibilities, powers are all being distributed vertically, and that is the federal structure that we follow in India. Apart from that, the judiciary system, apart from that, the public service commissions, the UPSC State Public Service Commission, Union Public Service Commissions. All right, so these are the main areas which we have taken, main principles that we have drawn from the 1935 Act. Apart from this, British Constitution, we have taken many things from the British Constitution. Number one, what we have taken from the British Constitution is the parliamentary form of government. Parliamentary form of government can be understood in a way that, you know, the legislatures and the executives are, there are two kinds of executive, as you might be knowing. The first part of the executive, the first type of the executive are those who are political executives, and the second type of executive are the permanent executives, the bureaucrats. We're not talking here about the bureaucrats here, we're talking about the political executives. Political executives are carrying two identities. Once, if they are in power, they become the executive. If they're in ministries, if they're in the ministries, as well as they carry another personality or another identity of being a legislature themselves. So you see, you have, say, 500 MPs. Say, suppose you have 500 MPs. Out of those 500 MPs, 251 would be those who will be forming the government. And out of 251, you'll have 15% of the 251 who will form the government, the ministries. And those ministries, those 15% would be the executive. But they are also the MPs, right? So executives are responsible to the legislature. This is the core principle of a parliamentary form of government. This is something which we have taken from the British Constitution. Apart from that, the rule of law, the legislative procedure, the single citizenship, cabinet system, prerogative writs. Writs you must be knowing under Article 32 and 226. There are 5 kinds of writs. So writs, parliamentary privileges, bicameralism, 2 houses, Lok Sabha, Rajya Sabha. They create a check and balance on almost all sorts of laws except the financial bills. To be honest, to be precise, the money bill. Rajya Sabha has very limited power in money bill. In fact, they has no power as such to hold on or to obstruct that bill. Now, apart from that, what we have taken from US Constitution, we have taken taken fundamental rights, the most important fundamental right, the independence of judiciary, judicial review, impeachment of the president, removal of the Supreme Court judges. There are many things that we have taken from America. Now, 2 things that you need to remember. That now, one is that what is the need of fundamental rights? It is important for an overall development of a human being. Fine. But what is the need to link that with the independence of judiciary? You see, independence of judiciary is one of the essential factors which will ensure your fundamental rights to be secured. Independence of judiciary will ensure your freedom. Independent judiciary will ensure that the government remains limited. It will ensure the government should perform on the constitutionalism principles. So these things will ensure our fundamental rights, and therefore these two are related. From Irish Constitution, we have taken mainly 2 things. Number 1, the directive principles of state policy, and number 2, the method of election of the president. You see, in India, there are 2 types of elections. We do not encourage direct democracy, wherein referendum, plebiscite, callback, these things we do not promote. What we have is an indirect elections, and in indirect elections there are 2 types. Number 1 is the first past the post system that we follow in Lok Sabha elections, and the another is which is basically based on the concept wherein the representative form of democracy, wherein the proportionalism principle applies. So one is proportionate principle based on which elections are being conducted, and another one is the first past the post system. We will go in details whenever we'll reach to those areas in the polity. So the election of the president is not based on first past the post system. It is based on the proportional principles, and therefore single transferable votes. So this process of the election of the president has been taken from Irish Constitution. From the Canadian Constitution also we have taken very important aspects. Say, for example, we have taken the central biasness despite being a federal country, despite being in the federation, the central the powers have been biased towards the center. So there's a inclination towards the center. So federation with a center bias has been taken from the Canadian Constitution. The residuary powers under Article 248 is being taken from the Canadian Constitution. We will go to these details. What is the residuary powers? If you want me to give a brief about residuary power means that whenever you see in Indian Constitution we have the 7th schedule. In that 7th schedule we have lists, and these lists consider of various subjects, which includes, there are certain subjects which are mentioned in union list, there are certain subjects which are mentioned in state list, and there are certain subjects which are mentioned in the concurrent list. So, and if something is not mentioned in either of these three lists, then the central government with the residuary power will make the laws. So you see, this residuary power is not being given to the states, it is given to the center. So there are approximately 22-23 areas wherein you can find that the powers are distributed in such a way that these are centrally biased. Say, for example, and let me give you another example, the initiation of amending the constitution procedure is not given to the state legislature. It can be only done through the central government, so union parliament. So there are many such examples which will prove that Indian constitution, despite being a federal constitution, it is central biased. Apart from that, the appointment of the governors by the center. Now this is very crucial in the present context, because there is a tussle going on between the governors and the chief minister, not only in West Bengal but also it is seen very recently in Tamil Nadu. People are questioning the credibility of the governors. There are judgments of Supreme Court also wherein it is said that the governors are not agents of the central government, but yet you can observe with their actions that these people are nothing but representing the central government. They are performing whatever has been instructed to them, and this is all because the governor post has become a political post. So these are areas which has been taken from the Canadian Constitution. The advisory jurisdiction of the Supreme Court, again taken from the Canadian Constitution, wherein the President will seek advice to the judiciary, take advice from the judiciary on a particular topic. This is mentioned in Article 143 of the Indian Constitution. Apart from that, what we have taken from Australian Constitution, in Australian Constitution we have taken the concurrent list, the concept of concurrent list. You see, this is important. Let me give an example to put this concurrent list into context. Very recently, the central government has announced or published the Electricity Rules 2020, and this is because for the empowerment of the consumers, right, for uninterrupted quality electricity. But the point is that electricity, the topic electricity is being mentioned in the concurrent list. Therefore, the central as well as the state both can make laws on electricity, provided that if central laws are in conflict with the state law or vice versa, then the state law will prevail. So this is the power of the central government, the central parliament, union parliament, when it comes to lawmaking in the concurrent list. All right, and same thing we have taken from the Australian Constitution. Next, what we have taken from the Australian Constitution is the joint sitting of the houses. Joint sitting of the houses means, as we have seen earlier, that bicameralism has been taken from the Britain Constitution, UK Constitution, wherein the idea is that there will be two houses. Just for example, what we have right now here is Lok Sabha, Rajya Sabha, and each of them puts a check and balance on the lawmaking procedures. Now, whenever there is a law which has been passed, whenever there is a bill which has been passed from one of the houses and been stopped by the other houses or voted out by the other houses, that there is a deadlock with respect to the bill, with respect to the future of the bill. In that situation, the president can call for a joint session headed by the Speaker of the Lok Sabha. Alright, now this system of Lok Sabha and Rajya Sabha, they're sitting together, headed by Lok Sabha, called by the president in a joint session, is only being set up for clearing the deadlock between the two houses. Now this procedure of joint sitting is a very essential part of the lawmaking process, of the parliamentary process, and this has been taken from the Australian Constitution. However, in the cases of amendment, you do not see joint sessions, but that is a whole different story altogether. We'll go back there when we will be discussing amendments. Apart from that, we have taken the suspension of fundamental rights during the emergency from the Germany Constitution, which is the Weimar Constitution. As far as the fundamental duties are concerned, the ideals of justice, we have taken from the USSR or the Russian Constitution. From the French Constitution, it is those three golden words: liberty, equality, fraternity. The same thing that was there in the French Revolution, the same thing has been taken from them. Apart from that, in South Africa, from South African Constitution, we have taken the procedure for the amendment. Very, very essential. The procedure for the amendment we have taken from the South African Constitution. Along with that, we have taken the election of the members in the Rajya Sabha. Rajya Sabha members' elections have also been, the procedure for electing Rajya Sabha members has been taken from the South African Constitution. These areas are very critical for your prelims. All these areas needs to be marked up. You read it or you listen to this video once or twice or even more than that, you will end up remembering these things, and these questions can be asked. Trust me, questions can be asked. All these words that I've been discussing, each and every word can be asked in your paper. The last but not the least, it is the Japanese Constitution, wherein we have taken the procedure established by law. Procedure established by law. The concept of procedure established by law has been taken from the Japanese Constitution. Procedure established by law means you see, in the way the judiciary performs, it has two tools. One is the due process of law, and the other is the procedure established by law. We will go back to those areas wherein the 1970s, early 70s, wherein the Supreme Court used to practice this principle of procedure established by law. That means the judges are bound to apply their mind only to the restricted area, the area that is mentioned in the law, which is established by law. Even if they have any doubt with respect to this particular situation, they cannot go beyond the words of the law. But in due process of law, the judges can apply beyond the letters of the law in order to attain, or in order to dispense, absolute justice, complete justice. So in procedure established by law, the judges or the judicial system is tied with the periphery mentioned in the law, with the jurisdiction that are bound. The judges has to follow that limitations. Whereas in due process of law, the judges can go beyond those limitations imposed by the law, and they can apply their mind in order to attain complete justice. So these two things are different. In India right now, after Maneka Gandhi case, the judiciary has adopted the due process of law, and therefore the Article 21 has been expanding so much since then. So the procedure established by law has been taken from the Japanese constitution. I hope we will discuss these things in very details whenever we will reach to those areas of chapters. As of now, this is the second salient features that we are about to discuss, and we have just finished it. The questions related to this will be in the description section. Do check that out, and thank you for your time. Please do subscribe to the channel. This video will be uploaded in Instagram as well as in the YouTube channel. Thank you.